Hello everyone, welcome back to my channel. Before watching this video, don't forget to like, comment and subscribe. Now let's start this video. Why is maritime law so important? The open sea and inland waterways used for commerce and considered navigable waters of the United States. Navigable waters are governed by a collection of laws and codes collectively known as maritime law. Maritime law, also known as admiralty law, provides important protection for those who work on navigable waters as well as passengers aboard vessels. However, maritime law is very complicated. As such, it is extremely important to seek knowledgeable legal counsel if you were injured or a loved one was killed on the open sea or inland waters governed by federal law. Patrick Danilo has extensive experience in the complexities of maritime injury claims. Know your rights under maritime law by contacting us today for a free case review. What is the importance of maritime law to maritime workers? The majority of workers on land can turn to state-administered workers' compensation programs if they suffer an injury at work or develop a work-related illness. If you work on navigable waters, however, the rules are different. Maritime law is only recourse maritime workers have if they are hurt on the job. Both the process of recovering compensation and the compensation available for a work-related injury under maritime law are different from filing a claim for workers' comp. The importance of the Jones Act. One of the most important components of maritime law is the United States in the Jones Act, or the Merchant Marine Act of 1920. To use the complete official name, the Jones Act established the right of maritime workers to maintain and cure for job-related injuries and illness. First, maintains refer to payment to help workers cover their day-to-day expenses. Second, cure refers to payment of medical expenses related to a maritime work injury. Sailor, offshore workers and other workers covered by the Jones Act, or known as seamen, are entitled to maintenance and cure. Employers are required to pay benefits for maintenance and cure until the worker reaches maximum medical improvement. Maintenance and cure are provided on a no-fault basis. This means that maritime employers are required by law to make this payment regardless of who may be responsible for the worker's injury. Unlike state workers' compensation law, which typically bar injured workers from suing employers, the Jones Act also allows seamen to sue their employers if negligence was a factor in the injury or accident. Specifically, employers can be held liable if their negligence, however small, makes a vessel unseaworthy. A vessel may be considered unseaworthy and the ship owner liable for any number of issues that cause harm to workers, including first, slippery condition on decks and other surfaces. Second, broken or missing handrails and deck railing. Third, failure to maintain and repair the vessels and equipment. Fourth, negligent training of crew. Fifth, failure to provide necessary safety gear. Sixth, negligent piloting and navigation on the vessels. Exposure to toxic materials. 7. Employing a skeleton crew, in example, not enough crew members to operate the vessel and perform work safely. If it can be proved that an employer's negligence led to injury or illness, seamen can bring a Jones Act claim for damage. You may be entitled to compensation for the following losses. First, current and future medical bills. Second, lost wages. Third, loss of earning capacity. Fourth, pain and suffering. Fifth, permanent disability. Sixth, scarring and disfigurement. 7. Loss of quality and enjoyment of life. Families of workers killed in maritime accident can also bring claims for wrongful death damage. Negligence or unseaworthiness must be provided for the workers' surviving loved ones to recover compensation. The importance of the Longshore and Harbor Workers Compensation Act. Originally passed in 1927 and amended multiple times since then, the Longshore and Harbor Workers Compensation Act, or LHWCA, created a federal workers' compensation program for employees in traditional maritime occupation such as longshore workers, ship repairers, shipbuilders or shipbreakers, and harbor construction workers performing work in or adjoining navigable waters. If you or a loved one has been injured while working on a dock, pier, wharf, shipyard, or maritime terminal, you may be entitled to compensation under the LHWCA. Benefits available under the Longshore and Harbor Workers Compensation Act include payment of medical expenses related to the maritime injury, coverage of vocational rehabilitation services, disability benefits partially covering lost wages, survivors' benefits in the event that a worker covered by the LHWCA dies on the job. LHWCA benefits are provided on a no-fault basis, meaning workers and their families do not have to prove that negligence was a factor in the injury or accident. Or generally, employers covered by the LHWCA cannot sue their employers. If a third party was negligent, however, additional compensation may be recovered through a spirit claim provided the evidence demonstrated that one or more third parties were at fault. What is the importance of maritime law to passengers? Passengers of vessels on the navigable waters of the United States also have rights under maritime law if they suffer injury or illness. The location of the accident is crucial for determining whether a claim falls under state law or maritime law. The right of passenger to recover damage for personal injury is an established part of maritime common law. Negligence on the part of a ship owner, the company operating the ship, and or a third party must be established for a claim to be viable. Different laws apply in the event of passengers' wrongful death aboard seafaring vessel. If the death occurs no more than 3 nautical miles from the shore, the personal injury law of the state applies. Meanwhile, the Death on the High Seas Act applies if the death occurs more than 3 nautical miles from the United States shoreline. The importance of the Death of the High Seas Act. Enacted in 1920, the Death of the High Seas Act, or DOHSA, is a federal statute that provides rights to families who lose loved ones to accident at sea as a result of negligence. The principal application of the DOHSA today is incident where passengers die on cruise ships that are out to sea. Under the DOHSA, eligible survivors such as spouses, children, parents, and other relatives dependent on the deceased can recover damage for pecuniary loss, in example, economic damage only. In evac, survivors can only obtain compensation for loss or financial support provided by the descendant prior to death and any funeral or medical expenses paid by the survivor. The descendant state is not entitled to compensation for funeral expenses and medical bills under the DOHSA In addition, family members cannot recover for non-economic damage such as loss of companionship and consortium, loss of parental guidance, and the pain and suffering of the deceased prior to death. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.